Hello, everyone. It's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another roadside chat. This question, I don't know where the officer is from, but he basically says, look, does the motor vehicle exception apply to disabled vehicles from a crash? All right. I worked a crash and one vehicle had heavy damage and was disabled. They ain't driving anywhere. While investigating the crash, there was an odor of marijuana coming from the vehicle, and the driver admitted to smoking marijuana in the car earlier that day. So there's definitely probable cause that there's going to be marijuana in that vehicle. A, it could be illegal in this state, I don't know where he's from. And B, it also might be evidence of a DUI. So a deputy on scene thought that the motor vehicle exception did not apply because the vehicle was no longer readily mobile and asked if we would need a warrant to search the vehicle. I say the motor vehicle exception still applies because we are not moving the vehicle to a secure lot. It's going to be like an open lot. We have tow trucks coming to get the vehicle out of the road, and then it's going to potentially be released back to the owner. So my question is, does the motor vehicle exception still apply to a vehicle that was disabled in a crash and no longer mobile? And the answer is yes and no. So generally what I teach is this. So being readily mobile or apparently mobile is part of the motor vehicle exception. However, I will tell you that courts will bend over backwards on this element. They will say things like, due to the vehicle being mobile just moments before, there's still the vehicle exception, the motor vehicle exception applies. There's still a reduced expectation of privacy. They'll say things like that. They'll also say because the vehicle is going to be moved, imminently, like there's tow trucks on the road on the way, that it still falls under the motor vehicle exception. It still has the potential to be moved. It's going to be moved. Now, if we have a vehicle that is not going to be moved, it's not going anywhere, and we know it also cannot be moved, then what I'm going to teach you is that to get a warrant for those cases, okay? However, if you have a situation like this, where the vehicle is going to be mobile soon, right? Because it's going to be hooked up on a tow truck, I would actually teach you that it still falls under the motor vehicle exception. Because it's the same kind of logic, by the way, and we have plenty of cases on this where disabled vehicles are searchable under the motor vehicle exception. Because the courts realize that they're going to be moved, in the future, right? So think about going out with a car that has a flat tire, it's dead battery, out of gas. Is that vehicle going anywhere? Absolutely not. But they have AAA en route, or they can get gas, they can get tires. Does it have the potential to move pretty quickly? The answer is yes. And courts almost unanimously uphold those disabled vehicle searches. Here, it's the same logic. This vehicle is not able to move right now, but it is going to be moved. But on the other hand, just remember, if you have probable cause for a vehicle that it cannot be moved, then you're probably done at that point, right? It's not going to be moved. It's going to stay there. You're going to grab your evidence and go. I would probably lean on the side of a warrant in that case, all right? We don't want to misuse and abuse the coveted motor vehicle exception. One of my favorite exceptions. I hope this helps, right? If you like this video, you know what to do. If you have any questions for me, my fellow instructors, please reach out to us at bluetogold.com. Ask your questions, leave a comment. Until next time, my friends, you stay safe.